use the words of the prosecution when this case was brought. This is not a homicide case, and it's not a manslaughter case. The evidence did not support felony charges of vehicular homicide or manslaughter. At best, negligence, which is insufficient for homicide. They even carried that same position into the last hearing we had when it was explained this isn't a homicide case. And you know it isn't, and that's what is the mix-up here with the family. They think it's a homicide case. You know, the simple fact of the matter is accidents happen, people die. It should not happen. Nobody wants anybody to die. Jason Ravnsborg didn't want this fellow to die. Nobody wants any family to suffer the loss of someone they love. And nobody blames a family for disliking greatly the person who is involved. And in this circumstance, he should not be treated or sentenced like somebody who's facing that type of a charge. He has lived a good life. He is an honorable man. He is not a coward. He has a Bronze Star defending our country. What happened out there that night could have happened to anybody. Anybody who's gone across rumble strips knows that it happens. Now, the statement was just said by Mrs. Beaver that he broke his own law while using the phone and that caused this accident. It is conclusively proven that that phone was not in use at the time of this collision. That phone, you can tell the exact second everything happened. You can tell coordinates and everything. And the phone was not being used from east of Highmore all the way through. This was an accident. She said that he was reckless. Well, guess what? Reckless has a defined meaning under our law. And if a person's reckless and causes the death of another, that is a homicide case, second-degree manslaughter. Those facts were not here. The first-degree manslaughter case requires that vehicular homicide requires that someone would be under the influence of alcohol or drugs. Nothing like that was here. There were witnesses all over the place where the Attorney General was earlier that evening, and not one person saw him take a sip. He generally does not drink. That's why these charges are not homicide charges. That's why we're not here today to deal with attempting to make right the death of Mr. Beaver. We're here today to deal with 2 misdemeanor traffic infractions, the lowest level of offense we have in this state, a Class 2 misdemeanor. So I've been through many sentencings on homicides, and they're like this, where everybody stands up and talks about how they want to be paid back for the death of the person, how they want the funeral expenses, how the state would want autopsy costs, all those different things. And I'm here to say nobody wanted Joe to die, but that's not the issue here. It can't be made right today. That's for another day and another venue and a civil action for a wrongful death matter by Mrs. Beaver, which she intends to file. So that doesn't have anything to do with the court's sentencing today. What's before the court are these misdemeanors. You have a person who qualifies for a suspended imposition of sentence. Just because he's the Attorney General doesn't mean that accidents can't happen. Just because he's the Attorney General and is involved here does not mean that the fix is in and there's some great conspiracy not to hold him accountable. I would submit to the court that any person in this state, from the highest to the lowest, if they would have been involved in something like this, with no alcohol in their system, no drugs, called 911 immediately, 18 seconds after the collision, met with the sheriff, talks with the sheriff, and then is allowed to go home and is even allowed to use the sheriff's car the way small town people will allow that to happen. Any person in those circumstances would not be looked upon as a coward, because a person who calls in 911 right away doesn't have anything to hide. They call in so that they can get help. And this contention that he had to have known that it was Mr. Beaver, that's just completely false. It's completely false. If you calculate the speed of a vehicle and how much it can travel, in the blink of an eye, a car can go 100 feet in a blink of an eye. In a blink of an eye. My client has been consistent from the beginning that he did not see Mr. Beaver. And nobody else who came to the scene that night did either. Everybody talks in this case about a flashlight, seeing a flashlight out in the grass. The tow truck driver didn't notice Mr. Beaver. The sheriff didn't notice Mr. Beaver. My client didn't notice Mr. Beaver. Nobody driving by noticed anything. And the next day, my client sees debris on the roadway and goes to kick it off of the roadway and sees this and immediately summons the police. My client was no coward. He did not walk away and leave someone unattended for any malicious or bad purpose. In fact, what were his actions afterwards? He goes in and he speaks to the North Dakota folks, gives them statements. He basically opens up and says, anything you want, hands over the phones, everything. This is not a man who had something to hide. He's a lawyer. And every lawyer in the world knows that if you're accused of a crime, you clam up and you shut up. But he didn't do that. He marched right in and he told them the way he thought it happened. This is hardly a guy who's trying to use his connections to improve his situation. He did that legally to his detriment because he has honor about him. Why is he not here today? Because people in our state have a right to have a lawyer appear for them on misdemeanors when it could be all something that they do not want to go through. That's his right. You have it, I have it, every person in this courtroom has it, every person in this state has it. If the highest law enforcement officer in the state can't take the benefit of the same rights that we all have, then who can? He has acted with honor in this case. And what has happened to him in this case with these political attacks is not honorable. And it has taken the focus completely away from the entire situation at hand. So what I'm asking the court to do is I'm asking the court to give him a suspended imposition on each count for 30 days, make him pay a fine and the court costs required by law, and give him a suspended imposition because he qualifies and society benefits about it. If the court wants to stretch that out beyond the 30-day maximum sentence, as is often done on these Class 2s, 6 months or whatever, then we don't want to suspend him. We just want the sentence, the 30 days on each, and go from there. I would also remind the court that the law is that if a person loses a jury trial, they can't face jail time, and that means suspended jail time too. Any jail time is not allowed, even suspended jail time. Now, I want to talk about restitution in this case. There are restitution requests, and they consist of funeral expenses by the mother. And we've also heard the state's attorney mention restitution to the county, although I think that might be a misnomer. I think probably they mean costs in that regard. As it relates to restitution in this case, under our statute defining restitution and what it is for, the court does not have the authority to grant restitution, and I will tell you why. 23A 28-1 says, "It is the policy of this state that restitution shall be made by each violator of the criminal laws to the victims of the violator's criminal activities." Criminal activities. The very next statute defines what criminal activities are. And when you have a definition within a code section, that applies to the statutes in that code section. And guess what 23A 28-2 sub 2 says? It defines criminal activities as follows. Quote, "Criminal activities," close quote, "includes any crime for which there is a plea of guilty or a verdict of guilty upon which a judgment of conviction may be rendered." Listen to that again. Any crime for which there is a plea of guilty or a verdict of guilty. We don't have a plea of guilty in this case. We have a plea of no contest. We don't have a verdict of guilty. A verdict is a decision rendered by a jury or a court after listening to the facts. It's not accepting a plea. Based upon 23A, 28-1 and 2, the court does not have the authority to grant the restitution requested. Furthermore, there is a request for funeral expenses. The request is made by Mr. Beaver's mother. First of all, I understand that that was insurance money that paid that. Now, I don't know that for sure, so I will tell the court I don't know that for sure. But if you look at 23A-28-2, restitution includes pecuniary damages, subsection 3. Pecuniary damages, all damages which a victim could recover against the defendant in a civil action arising out of the same facts. The only civil action available is a wrongful death matter. We know that Mr. Beaver's wife is the one who's going to file that, and we know that she is the person who has standing to do that. Under SDCL 21-5-5, a wrongful death action can only be brought for the exclusive benefit of the spouse or the children, and if those don't exist, then the parents. By virtue of the fact that Mr. Beaver is married, the mother has no standing to claim pecuniary damages because she could not recover any in a civil action. And what is restitution defined as under subsection 4 of that statute? Full or partial payment of pecuniary damages to a victim. So these damages under the law of restitution do not flow from criminal activities because it's a nolo contendere plea. You may ask why that would be. Well, because a nolo contendere plea keeps the matter out of a civil courtroom so that a separate jury under a separate action on a separate day can make the true measure of damages, which is the way that it is supposed to work. And that statute, SDCL 23A-28-2, is unambiguous. Now I want to move to the issue of court costs. First of all, if the state really is taking the position that these things are restitution, it's clear law in South Dakota that a county is not a victim for the purposes of restitution when a case is prosecuted and the county is not literally the victim in the sense that someone damaged county property or something like that. So let's talk about what costs they asked for. They asked for overtime costs of employees for doing their job. However, SDCL 23A-27-26 states costs shall not include items of government expense, such as jurors' fees, bailiffs' fees, salaries and expenses of special agents, reporters per diem. And then 23A-27-27 lists specifically the costs that can be allowed. Witness fees and mileage paid or ordered paid, including the fees of witnesses. Costs of transcripts, court-appointed counsel fees, filing fees, breathalyzer blood test fees, and other chemical fees may be included in the judgment for costs. These requests for example, the fees of the coroner, for example, the overtime of the highway folks that blocked off the highway as the investigation occurred, all of those things, those are salaries. Those are paid through the employment process. Everybody pays taxes. The money goes into the pool, and the public employees are paid. That's part of their job. That's something that is not authorized by costs. Here also, there's a request for the autopsy fee and the matters related to the autopsy and the travel to the autopsy and all that kind of stuff by the funeral home, the autopsy occurring over in Minnesota. And I want to read 23A-27-26 and talk about that. Judgment against defendant for costs, items excluded, enforcement is civil judgment. And the body of the statute starts off, quote, in all criminal actions, comma, upon conviction of the defendant, comma, the court may adjudge that the defendant pay the whole or any part of the costs of that particular prosecution. It says particular prosecution. What particular prosecution are we on here? We're not on the prosecution of a homicide. Just because that's investigated and not brought doesn't mean that the expenses related to that have to be paid by somebody if they are convicted of a small traffic infraction. So the prosecution that we have here for a traffic infraction is different than the prosecution for a death. And it's unfair and unreasonable to attach those costs, death costs, to a traffic infraction. With all this said, Your Honor, my client didn't want this gentleman to die. This was an accident. He has acted with honor. And the people who hate him will always hate him, and they will never change their minds. And the people who love him will always love him, and they won't change their minds. And what's going on here is he should be treated like every single other person in the world. And if you would have had anybody else in this spot where people couldn't scream conspiracy, false conspiracy theories, try to claim in court, maybe it's a legitimate belief, or not a legitimate belief, a realistic belief that they have, a sincere belief that they have, that Mr. Beaver was run down. People who run people down intentionally like a coyote, they get charged. This is nothing like that. This is a mere accident. Since this happened, 5 pedestrians in South Dakota have been hit and killed by motor vehicles, and charges involving the death have not been brought. And you know why that is? Accidents happen. And just because somebody dies doesn't make it a crime. So with all that said, I would ask for permission to pay the fines and legitimate court costs within the 30-day period, and I don't have anything else to say.